Hi, everybody. My name is Chris Bardenhagen. I'm a farm business management team educator, and I'm joined here with my colleague Sherry Burke, also on the farm business management team, and our esteemed presenter and special guest, Libby Sanderson from Sarah's Law Firm. So she's going to talk a bit about what families need to know about Medicaid. So, hello, Libby.
Awesome. Well, thank you, Chris, and thanks for everyone jumping on today. I know it's a gorgeous day and sun is shining, at least where I am. So hopefully I can tag along with you in the tractor wherever you are. Chris is talking me up far too much. I do not know everything when it comes to Medicaid, and I don't know anyone that does. So it's a complicated topic, and there's a whole lot going on. Um, so with that being said, we'll jump in and work through stuff as we go. And so a little bit more about me, about my background. I joke I'm a farm kid that went to school for too long. So I grew up on my family's dairy farm, and through that noticed that there's a lot of things that happen specific to the farm that not everybody knows about, whether that's your banker, your CPA, your attorney. Some of them have never set foot on a farm, and sometimes it shows. So when I set off through my educational career, I started at Michigan State and then went to Cooley Law School, but I always knew I wanted to come back and serve the people that I grew up with. So I have the farm background and it's my favorite part, but I really didn't want to milk cows again. So hence why I'm here. And outside of work, I am married to my wonderful husband, Jared, and we have our little boy, Isaac, who just turned 1. It's a little bit about today. So Medicaid's a big topic. We're going to walk through what it is, how to qualify, and some of the common farm pitfalls that we see with our clients. And I will give you a warning. It is my job to come up with everything that can go wrong, and usually it's the client's job to tell me if you care. I will probably sound a bit like a negative Nancy for a minute about all of the things that can go wrong when it comes to farm stuff, but it is still completely possible to qualify for Medicaid, but it is more complicated. So I know a lot of people are like, the farm is just another business, but we all know it is not. So a little bit about Medicaid and Medicare, just to kind of lay some groundwork and some definitions. So you'll hear people interchange them, but they are very different things. Medicare, you are entitled to when you're 65, and then income does not matter. So Bill Gates could qualify for Medicare. It just depends, your income depends on your premium. So Bill Gates is going to pay a lot, where most of us aren't going to pay that much. But Medicare also has limited long-term care coverage. So if you're looking at going into a nursing home or working with mom and dad on the nursing home plan, Medicare does not cover long-term stays. So if you're in a nursing home for 2.5 years, it's not going to cover that. It covers usually about a month. The type that we usually deal with is Medicaid. And under the Medicaid umbrella, there's still a lot of different types. There's the nursing home Medicaid that we're going to talk most about today. And then there's things like waiver, when that's where you stay home and someone comes into your home to take care of you. PACE and the Medicare savings programs, and each program has distinct eligibility. But the ones we're focusing on today are going to be the nursing home Medicaid, and I'll talk just a little bit about waiver and PACE, but those are kind of their own ball of wax too. So, in general, to qualify for Medicaid, someone must be 65 or older, or blind, or disabled. So, hopefully, for most of us, if we're looking at a nursing home care, we are over that 65, but it happens that you're not, and then that's where the other two can come in. So, then if we're talking about long-term care Medicaid, there are also additional eligibility requirements. You first must be medically qualified, which you might hear this referred to as someone has to fit through a door. That's not a physical door. It's a metaphorical door. And usually what it means is someone needs assistance with the activities of daily living. So eating, taking medications, um, bathing, toileting themselves, whatever those basic things are, this medical qualification comes from the nursing home or a medical professional telling us that yes, you're qualified. This is not something that we get involved with. We give you who you need to talk to have this qualification done, but this one's taken care of outside of the attorney's office. Then with the financial qualifications, that's where we get to come in. So we'll talk at large about this one. This is most of the presentation going forward is the financial qualifications. But the final piece is someone actually needs to be living in a nursing home or needing that in-home medical assistance. And a part of it, and you'll learn to see that I like analogies, but I think of Medicaid as like a puzzle. You'll get a few different puzzle pieces as you go, and then even if you come and see us or see a different attorney, my philosophy is we'll give you the puzzle pieces. They're all sitting there, we see the picture, but we can't lock anything into place until someone's actually in the nursing home or getting ready to go directly in the nursing home. That's when we can kind of finalize everything and have that puzzle all set to go. So I promised the financial eligibility part will take a minute. Here we'll jump in. So each program has its own unique asset and income rules. And assets and income are going to be treated completely separately. And we have to go through and define everything into one of those two categories. So the one we're going to talk about the most, the long-term care Medicaid, when it comes to income, the spouse, if the person going into the nursing home needs to have an income that is less than the cost of 1 month of nursing home care. Right now in Michigan, we're averaging anywhere from $9,000 to $12,000 for 1 month of nursing home care. This income eligibility is much easier to meet for most people because let's be honest, most people when they're looking at a nursing home care don't have that much coming in, but sometimes we still have issues depending on income sources that we'll talk about here in a second too. When we're talking about those waiver and PACE programs, that income limit is much lower. So that's $2,982 for the person going in the nursing home. And in any place that you guys see numbers in this presentation, especially for the recording, those are numbers as of today, and those can change all the time. So if you're watching this in the future, make sure you go look up the current numbers or contact someone who can, because I make no guarantees those numbers are going to be accurate. But as of today, they are. So then when it comes to income, what are we looking for? We're looking at any amount that you're getting from a pension, Social Security, and then my farm favorites. If you're leasing the farm or renting land, any income that comes in, we get to count as income. So whether that's selling crops or whatever, we're counting it as income when we're looking at the income number. So then that's tackling income. We can do things with that, and we'll get to that in a minute too. Looking at the asset side of things, this one gets a little bit more complicated. So both the long-term care Medicaid and the waiver PACE programs are the same for this one. And the person going into the nursing home, also known as the applicant, can have $9,950. And if you've been around Medicaid for a little bit, this is that old $2,000 number that we used to have for years. In 2025, the state upped that to almost the $10,000 limit that we're working with right now, which is very nice to work with. But again, that number is subject to change whenever the state wants to. And then as far as assets, if we're dealing with a married couple, the person that is not going into a nursing home is considered the community spouse because they are out and about in the community. They can keep half of the assets up to $162,660. This is where we get to play a little bit. If we're working with one single person going into a nursing home, we're still dealing with that $9,950. But if you're married, the spouse not going in the nursing home gets to keep $162,000. So, what counts as an asset? Assets count as anything you own, cash, investments, retirement plans, some trusts that we'll get into in a second, contracts for people to take care of you, believe it or not, can count as an asset. Your home and real property, farmland, the second house, rental properties, all of that counts as an asset. Vehicles, promissory notes, life insurance, funeral plans, annuities, anything you own, essentially all counts as an asset. However, the state does help us out and they make some assets that are exempt. And what that means is you own them, but the state looks at their value as a big old zero. So I like those. My goal is to always make as many assets exempt as possible. And what the state lets us do is they always assume the person going into the nursing home is going to come back home. So they want them to make sure that they have a place to come back to and they have things when they do come back. So the house, the homestead, is always exempt. And when it comes to farmland in Michigan, we don't have an acreage limit. Some other states say it can only be on so many acres, but we do get an equity limit, which is $752,000. So as long as we come up with a fair market value of the house and any acres that touch it that are less than $752,000, we're good with that. It counts as a big old zero. You did notice I said it has to touch. So that means if you have house in 40 acres and then your neighbors have a 10-acre parcel in between, and then you own the next 40 acres, if those don't touch, we're only counting the one that the house is on as exempt. Then we have to use the value of the one that doesn't touch. And we'll get more into that in a little bit too. Other things that are exempt, household and personal items. The stuff in the house, we're not going through and valuing absolutely everything. You get to keep your furniture, your kitchen utensils, all of those. One vehicle, and that is a vehicle that you can drive. Um, some people we've tried to get tractors and things through, it doesn't always work. But a vehicle that you can drive, take you to appointments, things like that. It can be an expensive car if you want. We can try to argue it with the state. I have never done a Lamborghini, but if you have one, I'm willing to argue it for you. But usually it's your everyday car. And certain prepaid funeral expenses. These are things, as long as they're marked non-refundable, we can count them as an exempt asset up to a certain amount. So all of these assets are things that aren't counted, but when you work with an attorney, whether it's us or another attorney, we still need to know about them. Because when we're submitting this application to the state of Michigan to pay for the nursing home care, we want them to say, oh, look, they have a house. Awesome. We're valuing it at $0. That way they don't think that we're trying to be sketchy. We just want to lay everything out to them, walk them through everything that we're counting as exempt and why. So even though they're exempt, still tell us about them. Other things that may be exempt is any cash accounts, but if they're jointly owned, we're looking at the entire value of that asset unless we can go through and show proof that the joint owner combined added things into that account. What that looks like is you have a bank account with the kids that you use as your farming operations account. It's not titled in an LLC, it's just in your own two names, and it's on there. That account has a value of, I don't do math, so we're going to go easy numbers, $100,000. If the kids are on there and we can show that the kids put in $50,000 on a certain day, and this is who, we don't have to count that. However, if we cannot show that and it's not clear, we count the entire value of that account, even though the kids are on it and they put money in there. So my one soapbox warning that I'll jump on for a second is please don't add the kids on the bank account just for fun or just so they can write checks if something happens to me. We can do things like a financial power of attorney that give the kids the authority to use that account if they need to for your benefit, but it also protects you if the kids were to ever be sued or go through a divorce. Because if their name is on that account as an owner, guess what? They can get into your account the other way. And a good attorney can make an argument against it, but it's still an argument they have to pay to make. So please don't add kids on the account to take care of things if you need them to. We have other documents for that, but that's a different conversation. Other assets that are jointly owned, usually we can value those in equal shares, except when it comes to property. and it is complicated and depends, and we'll walk through some of that. So, with property, the main thing that all of my farm clients are concerned about is you've acquired however many acres, and then we're trying to qualify for a program that only wants you to own your house and property up to $752,000. That doesn't work very well. So, property can count as an asset if someone has the legal right to use or dispose of it. What this looks like is, for example, my husband and I own 40 acres of farmland. If we wanted to farm that, we have the ability to. If we wanted to sell it to the next door neighbor, we're the ones that sign the deed. We have all authority to do with that land. If you don't have authority to deal with the land, which we'll talk about again in a minute, then we might be able to walk away from this asset. But usually, if you're on the deed, you're the one with the authority to use it and dispose of it. Or if the adjoining land is owned by others, what that looks like is that you own a house and 40 acres. And then the back 40, the kids went out and bought, but you needed to go to the bank and help them get the loan. So you're on it as well. Because the kids are on that back 40, even though it attaches to the house, we don't get to count that back 40 because someone else is on that. So it has to be in only your name or your name and your spouse, and no one else can be on that, um, or else it will count as an asset. And then finally, if the homestead is income producing, which with farm clients we run into a lot. You have the homestead, you're no longer farming, but you're renting it out. Those farm rents may cause the homestead to no longer be exempt. So something to look out for. So when does land not count as an asset? Because like I said at the beginning, my goal is to get as many things to not count as possible. This can come into play if you don't own it and you have no control over it, which right now, at face value, sounds pretty easy. Why would someone be counting land that I don't own in my bucket of assets? That's fair. But this is also where the irrevocable or irrevocable, depends on who you talk to, how they say it, that's where that trust comes into play as well. So with those trusts, the most important part is that you work with someone that knows what the heck they're doing with them. Um, we have clients that they weren't a farm family, but they have a house and a cottage. And about 12 years ago, they went to an attorney and they put the cottage in a trust and said, we want this to be in the family. It's been in the family for 80 years already, and we want to keep it going that way. We want to make sure if we ever need nursing home care, it's in the trust. Perfect. The attorney created an irrevocable trust, put the cottage in there. Clients went on their merry way. No harm, no foul yet. Well, last year, husband of the husband wife of this story needed nursing home care. So they come into us and say, hey, this other attorney we don't want to work with anymore. They went out of business or something, but we need to get nursing home care. Don't worry about the cottage. It's in an irrevocable trust. It's been 12 years. It doesn't count. Well, what happens was that attorney didn't walk them through things appropriately, and they put it in the irrevocable trust. They put their kids in charge of it, but they still had control over it, meaning they still paid the property taxes. They decided what to do with it. They put a new roof on. All of those things made it look like they still had control over that property, even though technically the irrevocable trust owned it. Before we got to submit everything to the state, we had to work through all of that and say, look, it looks like they're working on this property that they don't even own. Why would they do that? Um, we solved it. Nursing home care is taken care of. They're on Medicaid, everything is good. But it took a lot of work and it was not cheap for us to do. So if you set up an irrevocable trust, make sure you set it up with someone that will walk you through all of the ins and outs and also checks in on it every so often. At minimum, I always check in with my clients every 3 years because stuff happens and I want to make sure that we did it the right way and you're using it the right way. Because I can set it up and it can be all beautiful, but if it's not used the correct way, it still doesn't protect from anything. So usually if you set up an irrevocable trust with us, I know I said 3 years, but I'll really push you to come in once a year just to make sure everything's good. But this is a very viable option if we get to it soon enough. So you gift things into this trust and then you make a bet on yourself that you make it from 5 years of the day we signed that document until you need nursing home care. If you make it 5 years, it looks like that land is worth $0. If you don't, we made ourselves a little mess that we have to work out of. Solvable, not fun, but can be done. So that's a little bit of how the irrevocable trust works. If you take nothing out of today, besides if you're looking at an irrevocable trust, ask lots of questions. To whatever attorney you're working with, ask lots of questions. The other times that we can sometimes get property to not count as an asset is if someone cannot sell their share without asking permission from the other owners. And usually this works best with an unrelated third party. So we can't say, oh, I own property with the kids and the kids are unwilling to sell, so that way I get into Medicaid. I get Medicaid. It doesn't usually work like that. The state catches on to that pretty quick. What it can look like is, let's say, for example, I own property with Chris. We're not related, but we went in on farmland somewhere together, and then I need Medicaid. I call up Chris and he's like, there's no way I'm selling that land. I want it. I'm going to keep it. I'm not signing this deed. Because we're not related and they have no way, I'm then stuck. And it's an argument that we can make with the state that we can't sell that land because the joint owners aren't willing to sell it. It's still an argument and it's not as straightforward as I usually like it, but it can be done. So then other property issues. I promise that it's doable. This is where I said I'd sound like a negative Nancy. Other things we can run into is that if you were to sell the farm property or any property at less than fair market value, what that does is it creates what's called a divestment. And we'll talk about more as we go. But essentially, the state wants to make sure that you don't give everything away just to qualify for Medicaid. So this is where sometimes you'll hear people say, well, I sold the farm to my son for $1. It was a value, we're fine. The state doesn't care. It has to be fair market value. And we can determine that a couple different ways because if you're dealing with land, the values change every single day. But it has to be something that seems logical. Whether that comes from an appraisal, a comparative market analysis. Sometimes we can get away with the SEV. It just needs to be something more than $1 for 40 acres of land. And then the other one that can really cause havoc when we're doing Medicaid is a land contract, especially if you're selling on land contract. And I love land contracts for a lot of agricultural planning things. They're fantastic. Not so much for Medicaid, because if you're selling someone land on land contract, you still own that land until the contract is paid off. So we have to count it as an asset because it's still yours until that final payment. And we get to count the income that the person is paying you as income. So essentially, we have to take the value of that land twice and count it on any Medicaid application we do. So if you're looking at selling things on land contract, talk to someone first, especially if long-term care is looking like a possibility in the future. With all of that being said, the other things that happen with farm property a lot, and this is a very hot button issue right now too, is any income you get from wind turbines and solar. All of that income makes that land income producing. Also billboards. I have tons of farm clients who are like, oh, on the side of country road, whatever, this business pays me $100 to put their billboard up and I don't care, it's fine. We have to count that $100. Or if it's more, less, we're still counting it. Or if we're leasing land. So, all of that being said, how in the world do we actually get someone qualified for Medicaid if we have all of these issues? Um, and going back to the very beginning, we come up with all the problems, we can solve them, but we have to know about them to start. So I like to think about applying for Medicaid and working with the state of Michigan. It's like playing a board game with a 5-year-old. All of a sudden you're winning, everything's fine, it's going great. And then all of a sudden the rules don't change, but how they read the rules and how it's interpreted changes just a little bit. So now all of a sudden they're winning and you're losing. And that's kind of what we sometimes get when we work with the state of Michigan for Medicaid. The rules may not change, but how they're interpreted and how they're applied might change just a little bit as we go. So that's also where we don't lock it all into place at the beginning. We get all of the pieces right there, and then we say, okay, dad is going into a nursing home where he's already there, click it all in, and then we go forward. We can't usually do a hard, fast cut off, everything's in perfect plan because we have no idea what that caseworker is going to use when they look at the rules because the rules today may not be the rules next year. So other things that we work on for Medicaid is it all depends on the caseworker we get assigned when we submit that application. I can submit two identical applications, one in one county, one in another county, and each caseworker is going to come back with different questions and different approval spots. So if you get them on a good day, a bad day, it all depends. So that's again where we don't lock anything in until we know how they're reading those rules and how they're interpreting those. We also want to make sure that you keep records of absolutely everything. And I grew up on a farm, so I've done it my entire life. If you put all of your records in a boot box and you bring me the boot box, we'll dig through it. I'd rather you have it instead of not having it. Um, so whether that's receipts for buying a tractor, giving things away, selling something to the neighbor, keep records of it. And if you're like, oh, I don't have a copy machine, guess what? Most of us have these things in our pocket. You sell a vehicle to the neighbor, take a picture of the signed title, keep it in your phone. If we don't need it, we don't need it. But if we need it, it's on here. We can get it. So when in doubt, keep the record. Even if it's in the boot box, I might roll my eyes just a little bit, but we'll find it. um, Other things to be aware of, and this is a big one that we're working with in Michigan that just got a few changes made to it, is if you have a family member caretaker. Um, so the state assumes if you're related to someone that is taking care of you, they are doing it out of the goodness of their heart and they deserve no compensation. So, the daughter-in-law used to be a stay-at-home mom, but she was a nurse before that, and she is going to come in and take care of us, and I trust her completely. So we're going to write her a $500 a check every week because she takes care of us. If you do that, before we put what's called a caretaker contract in place, the state of Michigan says, well, you were gifting her $500. They don't care that she's moved in with you and she cooks every meal and does all of the things that a normal caretaker would do, and she's trained. The state doesn't care, and they say, no, because you're related, that's coming out of the goodness of her heart. We're going to penalize you for it. And so they do. But we can do things like the caretaker contract that allows that caretaker, family member caretaker to be compensated, but that contract must be in place before those payments go out. So again, talk to someone before you start doing some of these things. The other thing that a lot of people will talk about is the Medicaid spend down. That's where we go when we start spending money left and right to get under that $162,000 limit. There are things we can do with that money that can save it for either the spouse or the kids in the future. So you don't just have to go out and spend everything willy-nilly if you don't want to. And if you want to, great, we can do that too. But there are some strategies we can use to go through that if we need. And then finally, we've alluded to it a few times, a divestment. This is where you transfer either assets or income to someone else for less than fair market value. So, for example, my husband and I have that 40 acres we talked about. If we sell it, we list it with a real estate agent and it sells for fair market value, and then we need nursing home care 2 years later, no harm, no foul. It was fair market value. We're fine. I gift it to my family and say, here, I'm going to sell you this 40 acres because, I was just diagnosed with dementia and I want to make sure that I'm going to qualify for Medicaid. I'm going to sell it to you for $1. 2 years later, I need nursing home care. The state penalizes me for that gift that we made. So make sure if you do give things away, we keep a record of it. And that lasts for 5 years. So, with the irrevocable trust example that we used, that was done 12 years before they needed nursing home care. Perfect. It can work. If it's 5 years and 2 days, we're great. If we give something away and it's only 4 years, we have to do a little math and figure out what that penalty looks like and how we're going to come up with money to pay that. Um, and when I say penalty, we're not paying the money to the state. The state is just refusing to pay for your nursing home care until you pay for the penalty to the nursing home. So if you gave a gift of $12,000 and it's been 4.5 years, you need nursing home care. What we have to do is we have to pay for that penalty to the nursing home. What that usually looks like is you private pay the nursing home for 1 month. And then we're good. We get qualified for Medicaid and we keep going. So it's never we're just handing away money. It's you're paying for your care before the state comes in and pays for it. So then the other thing that we get a whole lot, but I can give away $19,000 a year and I don't have to pay taxes on it. Yes and no. You can give away $19,000 a year and not pay taxes on it. Talk to your CPA about that side. Um, but that's an IRS rule. That is not a Medicaid rule. So as far as we're concerned, if you give away $1, the state wants to know about it. That's a little bit of an exaggeration, but you get where I'm coming from. Even though it's $19,000 a year, Medicaid does not play under the same rules as the IRS. We have to do a little bit more covering than that. Um, so then when it comes to planning, because you're all here and like, well, okay, what do we do if we know about long-term care in the future? What does it look like? There's a few different ways we can do it. You always have the option of long-term care insurance. With those, it's an option. Talk to your insurance agent. I've seen them work, I've seen them not work, but it is a viable option. The other two ways that usually I look at planning for Medicaid is either estate planning with Medicaid in mind, which is just about every single one of my estate plans that I do, or we have our crisis Medicaid planning. And what that one looks like, the crisis Medicaid planning is, oh my goodness, mom and dad have never met with an attorney. They have nothing in place, and now they need to go into a nursing home, and it's going to be $13,000 a month. We don't have that money. What do we do? In the crisis Medicaid planning, there are things we can do at the time. It's a little bit more stressful for everyone involved. But there are things like Medicaid annuities and half a loaf, which is where we actually give things away on purpose, but then we retain money to pay that penalty that we were talking about. It can work. I much prefer to do it in advance. We have a lot more tools at our disposal if we do that estate plan with Medicaid in mind. And we'll walk through what that looks like in the example coming up, but it all can be done. It's just a matter of when you're ready to do it and what tools you want to leave open for us to use. So before we kind of jump into an example of how this can actually work, if you take nothing else away from today's presentation, if you can plan early, I know it's easier said than done, especially when or if you're trying to convince parents to do it, especially my stubborn farmers. They don't always want to get it done because they're invincible and nothing's ever going to happen to them. But if you can, plan early, revisit that plan often. Like I said, at minimum, we check in every 3 years because life happens, things change, we want to make sure it still works. If we're doing a complex Medicaid plan, I'm really going to push you to come in once a year, even if it's a 20-minute conversation. I want to make sure that this plan we put in place still works and there's no bumps in the road when we need it. Um, don't just set the estate plan on the shelf and never look at it again. Please, please, please. And then finally, consult with a qualified elder law attorney, whether that's me and my team or someone else, someone that's done this before and that you can ask questions to. And if you ask questions and you get crickets, please go somewhere else. Or if they say, oh, don't worry about it, it's fine, please find someone else. There are those of us that do it every day, and we want to make sure that you're working with the right people instead of the person that tries to make you their guinea pig. So, an example of how setting up an estate plan before you need Medicaid can help. Um, and keep in mind, this one only works with a married couple. Um, there are other things with individuals, but we're right now just going to focus in on that married couple and what can happen. So to lay a little bit more groundwork, even though we've been kind of doing that for the last 40 minutes, before we get into this example, when we're submitting a Medicaid application, the state of Michigan looks at two specific dates. They look at what's called the IAA date and the application date. So this IAA date is the first day that the applicant is in a home or hospital for more than 30 days. And that goes back as far as September 30th of 89. So if they've had a stroke before and they've been in a hospital or rehab for 30 consecutive days, then we use that date. Most of the time, I feel like my clients are just hitting this 30-day mark when they come to see us, when we're submitting that Medicaid application, so it's not the end of the world. But something to keep in the back of your mind if any family members have had a long consecutive hospital stay in the past, find that date and have that if we need it. Um, and then the application date is the day that we actually are eligible and we submit the application to the state. Typically, those two are at least 30 to 45 days apart, giving us about a month in between. But like I said, this IAA date can be way back years if we need it to be, or if it was. So, with that in the back of your mind, this married couple comes in and they do not have a trust. They've never seen us before, they've never talked to any attorney before, but now husband needs nursing home care. So they have a $200,000 house and they have $100,000 in cash in various accounts. And I'll warn you, these numbers are really easy because I don't do math on the fly. So right now, if they were to submit that Medicaid application, the house is exempt, the cash is worth $100,000. So on that IAA date, that couple was worth $100,000. So because they're a married couple, the spouse staying in the community gets to keep half. The spouse going into a nursing home only gets to keep that $9,000. So we cut it in half. The at-home spouse keeps half of the cash, $50,000. Then they have a spend down. They have to somehow get rid of $50,000, or 40,000 and change, before the state will come in and pay for that Medicaid, that nursing home care. Doable. You can easily go through and do things that make your exempt assets worth more. Like you can put a new roof on the house, you put new windows, you can get new furniture, things that would benefit the person coming back home. You can have those things done, but it's still $50,000 that you don't get to keep in your pocket. And then on the flip side, let's say these clients, this husband-wife couple, they've come in and they've seen us before. They set up a trust and they put the house in the trust, and then they come back and say, now it's time for nursing home care. What this then looks like is on that day they come in, on that IAA date, that house then is worth its market value of $200,000. Because the husband and wife do not own it, the trust owns it. So in this trust that we're talking about too is revocable, meaning the husband and wife can change it. It's very different from that irrevocable trust we touched on earlier, just as a little sidebar there. But on this day, the house is worth its market value because the trust owns it, and they still have that $100,000 in cash. So then that IAA number becomes $300,000 of countable assets. So again, we cut it in half for the at-home spouse to keep half. So they get to keep, the at-home spouse gets to keep $150,000. And then what happens is usually we'd say, okay, we have $150,000 that we have to spend down. How did this help us? What we do at that point is we actually deed the house from the trust back to the husband and wife as the individual owners. They still own the house, they still live there. Nothing changed that way. But because we changed that deed, that house becomes exempt and there's no spend down that needs to happen because the wife gets to keep $150,000, which is the entirety of that cash account. So with that, they're keeping everything, no spend down. That application was much simpler, and we're not panicking trying to get rid of $50,000. With that one being said, if we're taking the house out of the trust, and if any other attorney is doing this for you, please make sure that they set that house up in what's called a ladybird deed. What that does is it allows the house to go back into the trust when both people pass away without going through probate. Because you'll always hear the age-old wives' tale out there of, well, if I'm on Medicaid, the state can just come in and take my house, which is true, but only of assets that go through probate, which is where we actually need the judge to go through and help us move things to the new owners, usually the kids. If we have a trust set up or a ladybird deed and beneficiaries on things, we get to completely avoid probate court, which is always my goal, because then if the state pays for your nursing home care, they cannot come back and ask for reimbursement. And that is where you'll hear people say the state took the house, is if the house went through probate. If that ladybird deed is set up for it to go back into the trust when both people pass away, the state can make a claim, but there's no estate for them to claim it from. So therefore they don't get reimbursed. So make sure if you're taking something out of the trust, we have a way for it to go back in. Um,
It's a quick question. Is the Ladybird deed pretty much, I mean, that's pretty much the only tool for that, right? In this kind of case, right? You couldn't put it in a regular trust. You have to go Ladybird deed to the trust or to an individual. Is that correct?
yes. Yep. Because if it's in the trust again, then we end up with this big countable asset. So that's where we can use the ladybird deed to put it back once you pass away. Because once you pass away, I don't care what you own, and the state doesn't care what you own. So that's where we can put it back in the trust later. And the ladybird deed is the easiest and the best way to do that. So
Thank you.
yeah, I know that was a lot. Um, and I hope I didn't sound too negative, Nancy. Um, but when it comes to the state and Medicaid, farm families, we don't get a whole lot of special treatment. So Medicaid looks at it just as anybody else, and they don't care whether it's the home, if it makes money or they don't care it's a family farm. They only care if it's your home, if it makes money, and if you can sell it. So that's why, especially with my farm families, we don't get the option to just leave it up to the crisis planning because it doesn't give us all of the tools we need. If we plan ahead, it gives us all of the options to get it all planned the way you want it and to be able to save things and move things the right way. Um, so with that, I will answer a few questions on here if we can, or I'm always happy to answer them offline too.
Really appreciate your presentation, and we do have a number of questions. First question from Anthony: after a decision has been made and it doesn't go the way you expected, what fair hearing rights do you have, and how do you approach that?
So, I mean, I'm the best attorney out there and I never have a decision go the wrong way. No, I'm kidding. what you do is you can appeal with an administrative law judge, and then it actually goes to a court hearing. It's within the administrative courts of Michigan. It's not your general courts. And it's still due process as you would have in any other courts, but you can argue it. Um, it does, you can do it on your own. I would recommend an attorney to help you. And we can go through and have those discussions. And sometimes it's a simple error, and we try to start with the caseworker and say, hey, did you mean to look at it this way? And if they say yes, then we start the appeals process and go up from there. And this is where, from those cases, the Supreme Court in Michigan actually has the ability to pull those cases out and litigate them for other things. That's where we just got a new ruling with the caregiver contracts that came from something just like that. So there are ways through it. It makes the process longer. And sometimes, usually that's where I call in my friends that do litigation because they are better at it than I do. But we have options for that as well.
So what do you do with IRA type assets? Are they countable?
Yes, IRA assets are countable. Those are fun because those we cannot put into an irrevocable trust, or else you have to pay taxes on them, depending on the tax treatment going into that account. Um, so we have to count them, and that's where our things like our Medicaid annuities and our half a loaf strategies can come into play. Um, and long story short, yes, they're countable. What we do with them, I'll use the attorney answer of it depends. It varies on a case by case basis.
So there's different ways to deal with them based on the situation, basically. Are all the rules the same in all states?
They are not. Um, each state has to follow a um, specific federal minimum guideline, and then they can't impose over top of that. But each state has their own individual funness, I guess, when it comes to applying for Medicaid. So if you're looking at a different state, you have to consult with an attorney in that state, unfortunately.
Just to complicate the matter more, what if you live in southern Michigan, some property in Indiana, some property in Michigan? How does that look?
We put a big pool of attorney brains together. So if we're
Okay.
doing that, I'm working with an attorney in the states that you own property as well. Um, just to make sure, and I can't work with property outside of the state of Michigan. So even if we're writing a simple deed, you can only, as attorneys, we can only work in the state that you are allowed to practice in unless you take more bar exams, which is not on my radar anytime soon. So I will find a friend in that state and help.
Yeah, find a friend. Okay, so the next one is can we clarify the part about the acreage amount and 752,000 for the exempt home and acreage, I believe.
Yes. Yep. So the 752,000 is the homestead allowance. So if there's hundreds of acres attached to the home, we get to claim the $752,000, and then anything above that becomes a countable asset. Anything below that $752,000 is the non-countable side. But if there's tons of property attached, we can only claim that value as exempt.
So let's say, for example, you have an 80 and it's worth more like 900,000. And so that extra about 150 or 148,000, it becomes a countable asset. Now, how do you is there a way to deal with that and still qualify for the Medicaid?
Yes. How it depends. There's a couple different options depending on what it looks like at the time.
Okay, well, here's a good question. When or how does mental capacity impact any of the items in this presentation?
That's an awesome question. So if we're doing that estate planning with Medicaid in mind, the individual has to have capacity to make the legal decisions. So they have to know at basics who they are, what they're doing, um, and what they have. So if we're past that point, unfortunately, we're kind of just late waiting on that crisis planning. If we get into the crisis planning part, then the family can step in and take over things. The individual going into the nursing home doesn't have um, a whole lot of say in that. And that's where, if we've already made it to that point with no other planning in place, usually as part of this process, we're going to court and getting a guardianship and a conservatorship in place over that person because they can no longer make their own decisions. Um, if we get to do it while they still have capacity, that's where we can set up powers of attorney that would give them the ability to appoint someone, and that would be never have to go to court to do it. Um, so another pro to setting this up in advance is we get to do those powers of attorney as well, um, which functions the same way as the guardianship and conservatorship, but there's no court involved. So we can get around it. Um, and if we need to, we go to court to do it, but I much prefer to have the powers of attorney set up in place. But in order to do that, the person has to have capacity.
One more question on IRA assets. Do IRAs assets include RMD withdrawals?
Yes, those get counted as income. So
Okay. And then I have a couple questions. In a nutshell, when you have a land contract on the assets, the income side is pretty straightforward, would seem, but the asset side, how do you figure out? So let's say you're halfway through a $200,000 land contract that's got 10 years to go. How do you figure out what that's worth? How do you do that?
the state made it easy for us, and they say if the deed is still in your name, you still own it, and you own all of it.
Oh,
So yeah,
okay.
that's where I don't love those for Medicaid planning purposes. Um,
Right. Okay. But Medicaid planning is involved super cautious on the land contract. Um,
And when should they start planning?
I feel like the sooner the better, because you never know when. I feel like farmers move at the speed of their thoughts sometimes. So they're like, oh, I'm going to sell this piece of land on land contract, and the next day it's done. They have the ways to do that. So kind of the big part of my big key takeaway, especially for you guys, like the extension educators and things, that you guys have the inside pocket to all of those. Um, just warn them. Like if you hear them doing these things, hey, maybe you should talk to someone. Because it all depends and it all varies based on their situation. But a lot of these mistakes get made before we ever come into play. Um, so at least say if you're thinking about this, talk to someone first because this is kind of what could happen. Um, whether it's us or someone else, just run it by someone. That's my biggest takeaway. And when you should start is as soon as you can get them to. Um, it's all of it's changeable. And if it's not, we'll have that conversation of it's not changeable from here on out. So if we set it up today and 2 years from now we want to make a change, most of the time we can. Um, so that's my key takeaway is as soon as you can and before you do any of these things.
Thank you.
I guess I'd add to that too, don't be afraid to break through and talk to the attorney, just like Libby's saying, it's not it doesn't need to be as big of a barrier as it sometimes
Yeah.
feels, it's not just connect and see where things go. You'll be glad you did. There's a value in it. And yeah, I'd say on average the not waiting is a good idea.
Yeah.
So,
And we're not
okay,
scary. I promise most of us are, just farm kids that went to school for too long.
okay. Well, we're just at 1 o'clock, so I'm going to respect everybody's lunchtime. And thank you again so much, Libby. And we'll talk to you soon. And all right, everybody, have a great week.